Dave, did you give Ms. Garrett a copy of that citation provided to you?
I believe I can just hear.
Okay, great. All right, we're on the record on State of Florida versus Mr. Ke, 18 CF 0435. State, are you ready to proceed?
Yes, Judge.
All right, defense?
Yes, sir.
All right, the jurors are here. We have one pretrial motion we needed to resolve before opening statements begin that I passed till today so that the state could provide some case law to the court. That was the motion in limine number 1 that we went over yesterday, in which the defense is asking that the court limit out the state from characterizing or referencing to Mr. Tudor's death by either the prosecutors or the witnesses for the state that the killing was either execution or execution-style killing, and the defense provided me with the Brooks case versus state cited at 762 Southern 2nd 879, and then this morning Mr. Sturry for the state provided me with a Supreme Court case also. Brooks was from 2000. This is Gonzalez versus state, cited at 136 Southern 3rd 1125, which is a Supreme Court 2014 case, which I have had an opportunity to read both cases. Ms. Garrett, did you have an opportunity to read the case?
I did have a chance to review it this morning, Ms. Chairman.
It looks like on page 6, kind of on the second section over there, the Supreme Court goes on. It doesn't cite Brooks specifically, but it says, we have warned that the use of the word, and I will note that this is during the guilt phase, not the penalty phase. Yours was during the penalty phase. This is during the guilt phase. So I don't know that's why they didn't cite one another, but the Gonzalez case says we have warned that the use of the word exterminate, which I'm sure the state wasn't going to use, or any other similar terms which tends to dehumanize or demonize a capital defendant is improper, cited to Bonify, that's B-O-N-I-F-A-Y, the Supreme Court case. It says, we concluded that the prosecutor's singular use of the word exterminate did not constitute harmful error. We find that though, and talking about the Gonzalez case, it says, we find that the prosecutor's comment in this case was proper as they were based on the fact that Mr. Billings was shot execution-style in the back of the head. The comments also are not of the type of egregious, inflammatory, or unfairly prejudicial remarks that would require a trial on the question of Gonzalez's guilt. So I don't know all the facts in this case. I do know some of the facts. So state, do you intend to use the word execution or execution style? That's the first question. I don't even know if you intended to use that or it might come out during trial.
Intent is an interesting word, Judge. I don't have a script where I intend to use the word. However, I know Your Honor was a trial attorney. There's a lot of different descriptive words that we use during the course of the trial, and I don't want to foreclose the possibility that I do. Our theory of the case is that the defendant specifically came up at the victim at gunpoint while the victim was kneeling on the grass with his hands up, shot the victim so that he could get a better shot at the back of the victim's head, and then he shot the victim in the back of the head, execution style. So.
Well, in most cases, and I was a trial attorney, opening is a little more scripted than closing. Are you intending to use the word execution style or more?
It is not my intent.
It's more likely you use helpless or those type of words?
Yes.
Okay, Ms. Garrett?
Your Honor, essentially, I think that in prior hearings in this case, Mr. Strager or members of the state attorney's office have referred to this as an execution killing. My concern here is primarily to just ensure that unnecessarily inflammatory language is not used to describe this by the state. This is already a situation where they're going to have a video to rely on. The court's already made a ruling on it. So they're going to have a lot of things that they can rely on to allow the jury to characterize the death in the way that they're going to do it, which is what it's the jury's job to do. So I would just ask that the court
but the state has indicated that they don't intend to highlight this as an execution or execution style killing in their opening or their closing. I was most concerned that a witness might say it, and you know, you can't really script what a witness says. So I will deny the motion in limine, but I will ask that you know, both sides stick to the facts of the case and not try to put more inflammatory instances on both sides than is necessary to, you know, show the jury what happened and for them to make a decision. Of course, if you feel that the statement is improper, you can make a contemporaneous objection, and I would rule on it. So I'm not saying that it's allowed anytime somebody wants to say it. I'm saying I'm not going to limit it out. It has to have some sort of meaning within a definition where, you know, like a dictionary definition, and the state's indicating that that's not the path by which they're going. I will note that in the case you cited, Brooks, they actually commented that this was the third case they overturned twice with the same prosecutor for using almost the exact same language. So he was basically scripting his closings into a way to use this kind of language on a regular basis. They actually noted page for page his closing argument in 2 different cases, but again, it was in a death penalty case. So again, we're talking about guilt phase, we're not talking about penalty phase, somewhat different there. But I'll just ask the state to stick to the dictionary definition that you used yesterday and not try to make it, you know, more egregious or inflammatory type of language. We can do that. If it slips out, if it happens to slip out from a witness, it happens to slip out from the state in some descriptive manner, you know, if there's an objection, I'll make a ruling on it, but I'm not limiting it out completely. I don't know what these people are going to say, and in this particular case, I know that from what I've read, there was a shot, the victim was injured, he was still alive, and then he was shot again at close range, using a non-descriptive name. So there may be someone who uses that word to describe it, but let's try to keep it to a description, not to make it inflammatory. Everybody agree to that?
Yes, sir.
All right, so the motion in limine is denied, but the ramification, you know, I've kind of made some boundaries there. So, State, are we ready to go?
Almost, Judge. 2 matters. One, I'd like to file a stipulation that was signed by myself and Spear and the defendant may approach.
You may. Is this ID in the body?
Yes, Judge.
Okay, that's fine. Just let me know when you want me to read it.
And also, per the hearing in court last week, I indicated that there were some family members who wanted to be present in the courtroom who we had previously added to the witness list, although we do not intend to call them. So I would list those in court now. I've already informed Mr. Pura,
Okay.
and he has no objection. They are Mary Tudor, Delbert Tudor, Alexander Smith, and Tiffany Hughes.
All right. Guys, do you have any objection to them sitting in? Okay. Go ahead.
And I would also note for the record that I've had a conversation with all of the people here on behalf of the victim, and to behave appropriately, and we don't anticipate any issues on that.
Okay, and the one thing I want to add to that is we did tell the jury yesterday that there will be a video of the killing, and that's going to be shown, and I see we have the big television. So I assume we're going to play it on the big television.
Yes, sir.
Which is fine, you can present your evidence any way they want. But if there's any family members who do not wish to be present, who do not think that they are able to, you know, review that, they're more than welcome to either, you know, go over to the other side where they can't see, because I won't be able to see the camera. It'll be facing the jury. Or to go ahead and stand up and walk out into the hallway. I have no objection, you know, you can move around as you want as long as you keep you know, the noise down. So if they don't think that they can watch that part of it, or the medical examiner when they show some photographs, I have no problem with it. If the victim's family or friends think they can't watch that they, you know, go ahead and leave at that point, and we'll make sure that they know that's coming up. So make sure we announce, hey, we're going to put the video on of the shooting, and that way, if they want to go, they can go at that point. Okay? Other than that, anything else? Defense, anything else?
Regarding opening statement, Your Honor, we're going to be reserving our opening statement until after the statements.
Okay, no problem. Mr. Key's been here. Mr. Key, we're good? Okay. All right, we're going to go ahead and bring the jury up, and we'll begin as soon as they arrive with preliminary remarks from the court. Then the state will do their opening statement. I'll have you reserve on the record, and then we'll move on with the first witnesses. So state, you'll have your witnesses ready outside?
Yes, so the witnesses are all outside already.
Okay, great.
Judge Schneider's drafting these right here.
That's fine. For the preliminary instructions, I refer to the indictment as a piece of paper. I can read information or indictment when I read the preliminary instructions. Does anybody really care? I mean, it is an indictment. I can read indictment. I just don't usually call it an indictment when I'm picking the jury, because then they ask me what the difference and to get in the whole conversation. It's not necessary.
All jurors present this evening.
All right. Good morning, ladies and gentlemen. How are you?
Good.
You guys are great. I have the boxes here. If you could pull out any electronic devices that you have, make sure they're on the off setting for me. We're going to go ahead and place them in the boxes as I indicated earlier. They'll just be here at a door of the courtroom. If anybody needs a phone number for anybody home, work, whatever, when we take a break, my bill has a phone number. My judicial assistant is downstairs in the office, and she will be throughout the trial, so the person can call her, and then she'll send me a message and I can take a break. So if anybody needs that phone number, just at our next break, just have my bailiff for it, he has that number, just so you can provide it to everyone. Did everyone follow my instructions? No tweeting, texting, blogging, talking about, visiting, looking at the same key times, anything like that? Everybody followed those instructions? Yes? Yes. Excellent. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Qiu Feng Ke. This is a criminal case, and the defendant is charged with the crime of murder in the first degree. The definitions and elements of that crime will be explained to you later. It is your solemn responsibility to determine if the state has proved its accusations beyond a reasonable doubt against Mr. Ke. Your verdict must be based solely on the evidence or lack of evidence and the law that I will give you at the end of the case. The indictment or piece of paper that I read to you yesterday is not evidence, and it is not to be considered by you of any proof of guilt. It is my responsibility to decide which laws apply to this case and to explain those laws to you. It is your responsibility to decide what the facts of the case may be and then to apply the law that I give you to those facts. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful for you to understand how the trial will be conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. I remind you, however, what the lawyers say is not the evidence, and you are not to consider it as such. Following those opening statements, witnesses will be called to testify and placed under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced into evidence. If it is produced into evidence, it will go back with you into the jury room. After the evidence has been presented, the attorneys will then have an opportunity to make final arguments. Following those arguments by the attorneys, I will then instruct you on the law applicable in this case. And I will tell you that that law will be in writing, and each of you will have a copy of it as we go over it, and you will be able to take that copy with you into the jury room. After the instructions are given, I will then release the alternate, and we will then retire for you to consider your verdict. You should not form any fixed or definite opinions on the merits of the case until you have heard all the evidence, the the arguments of the attorneys and the instructions on the law that I will give you. Until that time, you should not discuss the case among yourselves. I now instruct you not to communicate with anyone, including your fellow jurors, about the case. No communication includes no email, text message, tweeting, texting, blogging, or other forms of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules at all, please notify my personnel of the violation immediately. During the course of the trial, we will take recesses and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you are a juror trying the case and ask them to stop. If they persist, leave them at once and immediately report the matter to my bailiff, who will advise me. All cell phones, computer tablets, or other types of electronic devices must be turned off while you are here in the courtroom. Turned off means that the phone or other electronic device is actually off and not on the silent or vibrating mode. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recording, or audio recording of the proceedings or of your fellow jurors. After each recess, please double check to make certain that your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or electronic devices. If someone needs to contact you in an emergency, I will receive that message, deliver it to you, and without delay, I will provide you with your cell phone so you can contact them back while we take a break. The case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and myself. Jurors must not conduct any investigation of their own. This includes reading the newspaper, watching television, or using a computer, cell phone, the internet, or any electronic device, or any other means at all to get information related to this case or the people or places involved in the case. This applies whether you are here at the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial, nor use the internet to look up maps or pictures to see any place discussed in the trial. Jurors must not have discussions of any sorts with friends or family members about the case or the people or places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you are not to talk about this case face to face, you must not talk about this case by using any electronic devices. You must not use your phone, computer, or electronic device to communicate about the case until the case is concluded. Do not send or accept any messages related to the case or your jury service. Do not discuss the case or ask for advice by any means at all, including posting information on internet websites, chat rooms, or blogs. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented here in the courtroom. If you investigate, research, or make inquiries on your own, I would have no way to make certain that the information you obtain is proper for the case. The parties likewise would have no opportunity to dispute the accuracy of what you find. That would be contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror would unfairly and improperly prevent the parties from having that opportunity our judicial system promises. Any juror who violates these rules jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and of course, you, the taxpayers. If you violate these rules, you may be held in contempt of court, face sanctions such as serving jail time, paying a fine, or both. In every criminal proceeding, a defendant has an absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a juror is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said if he or she had been permitted to answer the question. During the trial, it may be necessary for me to confer with the attorneys out of your hearing to discuss matters of law or other matters that require my consideration alone. It is impossible to predict when such a conference may occur or how long it will last. When such a conference occurs, they will be conducted as to consume as little of your time as necessary for a fair and orderly trial in this case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. I have provided you with notepads and pens for your use if you wish to take notes. Any notes that you will take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, my bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver the notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as an aid to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of another juror. Notes are not entitled to any greater weight than each juror's memory of the evidence. You won't be able to take them to lunch, but they do go back with you into the jury room when you deliberate. So just during lunch breaks and when we break for the night, you leave them on your seat. You have the manila envelope in front of you. Inside is the pads of paper, pens, and pencils. If you run out of any of that, please raise your hand. We have more in the drawer. We'll stop, bring you over. I know pens run out all the time. Just raise your hand. My bailiff will bring you another one. All right? State, are you ready to begin with opening statements?
Yes, sir.
You may proceed.